and welcome to the SIAC Russia webinar, the SIAC Advantage for Russia-related projects and transactions. As many of you would be aware, Russian parties have started to have somewhat of an eastward shift and are looking at Singapore as a preferred destination for arbitrations and SIAC as a preferred institution. SIAC is now registered as a permanent arbitral institution in Russia, which will further enhance our ability to administer Russian-seated arbitrations and certain categories of corporate disputes. This has been a long period of engagement for SIAC with Russian parties. For my part, I've been traveling to Russia for the last 6 or 7 years. Aliona, my co-moderator, has Russian language capability and has been a big part of SIAC's outreach. We have Russian members of the panel of arbitrators. We recently administered a bilingual arbitration to a certain degree where the award was drafted in Russian and English. And this is all part of what we're trying to do to make Singapore and SIAC an attractive place for Russian users. From a Singapore standpoint, as Paul will be discussing in the first session, what Singapore has done very well is to try to make arbitration accessible to both common law and civil law practitioners. Every time I look at the map, I realize that Singapore and Malaysia are two common law jurisdictions surrounded by a lot of civil law jurisdictions. So that really imbues everything that we do in Singapore, is to make sure that it's accessible to both. We are absolutely delighted with the group of panelists that we have today. I've been looking around at every ranking list, and it seems that these panelists are on every single one. They have experience as both counsel and arbitrator, and hopefully we can get these perspectives. We'll start with Francis Xavier, who's a prominent senior counsel and partner and regional head of dispute resolution group at Raja & Tan, and a member of the SIAC panel of arbitrators. We also have Dmitry Dyakin, who is a new member of the SIAC Court of Arbitration. Dmitry, we are delighted to have you on the SIAC Court, and he's a partner and co-head of dispute resolution at Rybalkin, Gortsunyan and Partners. Nicholas Lingard, very well-known arbitration practitioner in Singapore, a partner at Freshfields, Brookhouse, Derringer in Singapore. Paul Tan, also very well-known in Singapore, a partner at Kavanagh Law, which is registered in a formal law alliance under Clifford Chance Asia, and he is also very active as a member of Young SIAC. And Julia Zagonek, who's a partner at White & Case in London and a court member of at least a few other institutions. So the way that we're going to run this is we're going to look at the dispute resolution regimes in Singapore, Russia, what it's like to run an SIAC arbitration, the impact of SIAC's registration as a permanent arbitral institution, and of course, the impact that sanctions have on the arbitral process. So Paul, if we could call on you to perhaps give an introduction to the Singapore dispute resolution regime, the choice of Singapore as a seat, and any particular advantages that you would see for Russian parties.
Thanks a lot, Kevin. Very good afternoon and good morning to all of you. So, a few years back, I had the pleasure of visiting Moscow with our Ministry of Law as part of that engagement that Kevin was talking about. And I think that there were 2 points that we kind of came away with. One, I think it's no secret that Russian parties have traditionally chosen London courts or arbitration, no doubt in part because of the stability and reputation of the English legal system, and perhaps even the common law. Second, however, because of the sanctions, which again, Kevin has alluded to, I think that proposition has been stress tested in recent times. And I think we are seeing a reconsideration of Russian businesses in terms of looking eastwards occasionally, and I think often through Singapore. So I raise these 2 points because I think when we talk about the SIAC advantage, which is what this webinar is about, it's not really just an abstract concept of which institution is better or which seat is safer. But there's real relevance depending on who is sitting on the other side of the table when you're negotiating your contracts and your transactions, and if or when those disputes arise. And if there's anything to take away at the end of the presentation today, I think, or at least on my part, It would be, first of all, I think you'll find all the advantages and pluses of London in Singapore and in the SIAC. Of course, they're not synonymous necessarily, but they tend to come together. And second, I think if you do have an Asian counterparty in particular, I think you'll find that the SIAC is a perfectly acceptable and very obvious and desirable choice of institution for your transaction. So if I could just ask Sue to pull up the first slide of my presentation. Thanks, Emily. So we can go to the first slide. And what I would like to start out with is this broad overview of where Singapore sits as a dispute resolution hub. And although we are concentrating here on international arbitration, I think the reality is that disputes nowadays are complex. There will be parts of which that will end up in arbitration, but there may well be parts of it that end up in court as well. Equally, even if one starts the dispute in arbitration, they're setting aside jurisdictional challenges, injunctions that you might need, and so on and so forth. So the point here really is that if Singapore's litigation scene as well is a very reputable one, primarily operates on the basis of the common law, which borrows from the English common law system. So it's adversarial in that nature. But there is no necessary assumption or preclusion of any application of foreign law, even in the courts. So as Kevin was mentioning, if your contract is governed by a civil law system, that's completely fine, and that's perfectly fine. And I think what reinforces that point is the fact that in Singapore, in the last, I think about 6-7 years ago, we started a division of the High Court known as the Singapore International Commercial Court. And that court has an international panel of judges coming from both common and civil law jurisdictions. And in particular, that court is also able to hear arbitration-related litigation. So then if we move on to the arbitration square or triangle, you will no doubt have read in the press that this year, at least, we are top ranked alongside London in terms of our reputation for being a safe seat for international arbitration. We are a model law jurisdiction, so we follow international practices. There's very little deviation from that, although there are some sort of fine tunes that have gone into the legislation, which we can come to in a second. You have choice of institution, choice of counsel, choice of law, choice of arbitrators. There's absolutely, as far as I'm aware, no restriction as to how you wish to structure your transaction and how your dispute can be run. And of course, recently as well, legislation has been promulgated to enable third-party funding as far as international arbitration is concerned. We also have mediation facilities, so it's not uncommon nowadays with more complex transactions that you have, for example, pre-arbitration mediation requirements, or parties may wish alongside arbitration to also have mediation. And we have facilities and institutions in Singapore to facilitate that. Singapore, of course, was also at the forefront of negotiating an international convention which will recognize settlements arising out of international mediations and the enforcement of those settlement agreements in whichever country has signed up to the convention. Last but not least, Singapore is also part of a global network of treaties. And I raised this point, well, the two kinds of treaties that we're talking about. First, reciprocal enforcement, and that may be key depending on where assets are, where your dispute can spill over into. That's something which is sometimes overlooked in terms of choosing a seat. I think you want a seat that's well connected and whose judgments and awards are readily enforceable in as many jurisdictions as possible. Second, of course, if you're thinking of structuring your transactions, Singapore is at the center of numerous investment treaties, particularly in Southeast Asia, but I think across the world as well. So the coverage that you get in terms of investment protection is also extremely high. And that's something which one can bear in mind also in terms of selecting where to structure your investments, and often with that also what choice of seat you want, as well as what institutions you want to govern your dispute. Can move to the next slide, please. All right, this is just a very old article about the Singapore-London axis. I think the only point here to be made is really that we have a lot of connections in terms of law, in terms of institutions. We're not necessarily competing, but I think you can see Singapore and London as being complementary in many ways to your overall investments and to your overall dispute. Let's move on to the next slide. I think the other point to make, of course, is that Singapore's dispute resolution scene is well supported by the judiciary. And that's a huge plus, and we're very lucky to have that independent judiciary. And that judiciary is one which is well trained in international arbitrations and international litigation. You'll see many examples of cases which have enforced the New York Convention and obligations to arbitrate. There is interim relief support for arbitrations, both seated in Singapore and elsewhere. The courts repeatedly say that they are pro-arbitration, and there's minimal curial intervention in awards that are rendered. Awards are regularly upheld, and the ability to set aside an award or to refuse enforcement is only limited to the grounds which are permitted under the model law or the New York Convention, and even those are read extremely narrowly. So the whole system is geared up to really support international arbitration and dispute resolution in Singapore. Next, please. We also have the fortune of having a government which is extremely supportive of international arbitration. So what I've done here on this slide is really just to show the regularity with which the government reviews our international legislation, international arbitration legislation. So you can see from 2010, 2012, and then most recently, there have been numerous revisions and refinements, most recently including powers to enforce confidentiality. We now have default provisions for multi-party cases, and there is now statutory basis as well to dispel the ambiguity over the arbitrability of intellectual property disputes. Let's move on. There's infrastructure here as well, which is well recognized globally, including Maxwell Chambers, where many of the arbitrations are held. And of course, in an era where we could travel, we could top-class hotels. But even now, I have to say, the support that is given to remote hearings is of an extremely high level. So there has not been, at least in my experience, any trouble linking up with Maxwell Chambers or SIAC or any of the institutions with regards to the support that is needed for electronic or remote hearing. Can move on. All right. We also have obviously lots of law firms in Singapore, although you're not limited to any particular law firm necessarily. But just to say that, if, for example, one needed to go to court, which is at the moment regulated, there is any number of law firms that are available for you who are well recognized internationally for international arbitration related matters. We can move on. And of course, we come to the reason we're here, which is the presence of strong institutions, and the SIAC in particular. You will no doubt be familiar with the fact that the SIAC is an extremely strong institution, globally recognized. The number of cases have been increasing year on year. I think this year we again reported record numbers and very, very high numbers. And I think what's particularly useful for Asian parties, I suppose, are two things. Number one, SIAC now has representative offices across the world. So regardless who your counterparty might be, I think you can be assured that there will be assistance and infrastructure available to you. Second, of course, the SIAC, like the Singapore government, I think is always on the lookout for innovations and always refining their rules. I think they're undergoing a review at the moment, if I'm not wrong. But one example of that sort of innovative thinking is, of course, the International Investment Arbitration Rules that were promulgated in 2017, which I believe Nick will be talking about a little bit later. So that just goes to show the SIAC's presence and the SIAC's ability to deal with growing issues that confront parties. We can move on. This last slide really just summarizes the various aspects of an SIAC arbitration, which I think the next panel will talk about. But essentially, I think what you'll find is that all the mechanisms and procedures that are necessary to handle a complex international arbitration are available under the SIAC rules. So you have early dismissal of claims and defenses to speed things up. I think we were one of the first to introduce international emergency arbitrations as well, and that has obviously taken off very well. We've got expedited procedures for smaller cases or urgent cases, it's gone through sort of revisions on the joinder provisions, multi-contract and consolidation provisions as well. So all of these provisions collectively, I think, enables any party, international, Singapore, Asian, and Russian, to conduct their arbitrations in a way that is efficient and effective. I think that.
Thank you, Paul. I noticed that we're starting to get questions from the audience, but Aliona and I, as moderators, we have questions of our own. I'm wondering if you could explain the considerations and how it exactly works to make an application to the Singapore International Commercial Court. So for instance, you indicated that the International Arbitration Act has been modified so that there can be a de novo review of negative decisions on jurisdiction. How exactly does that work? We know that the legislation has been clarified. The Singapore court's very pro-arbitration, but in what circumstances could an application be made to the Singapore International Commercial Court?
Yeah, so I think that there are two ways that can happen. One is that the case gets transferred. So you file the application in the general, what we now call the general division of the High Court, so what you would be familiar with. And then because of its international nature, the court may ask parties whether they want to transfer that to the SICC. That's the most common way in which that's done. There is also the possibility of actually filing an application to the SICC directly as well. There is a third way, which is potentially to agree in the arbitration clause that any related litigation be heard by the SICC. The third one is still untested in the sense that, or at least as far as I'm aware, I don't know if Francis has more experience on this, but I think theoretically the option is available for parties to agree, as with any jurisdiction clause, that it be heard by the SICC rather than the general division. And my sense is that will probably be upheld, but we are having sort of kind of informal chats with the courts about how we can make this a bit more certain for parties who are thinking about it.
Are there any practical tips, say for a Russian party that's about to conclude a transaction right now and they're deciding on Singapore and SIAC, in terms of virtual hearings, wet ink signatures? Are there really, I guess, like elevator pitch tips that you need to be on the lookout for in a Singapore seated arbitration, whether SIAC or the 5 other administering institutions?
Well, you have to give me some time to think about this. The only reason I'm hesitating is because as far as I can think of at the moment, there isn't any hindrance I would say, to the efficient conduct of these proceedings in Singapore. There isn't those requirements of wet ink signatures, any formalities that need to be you need to be aware of that you could sort of fall prey to, or any of those sorts of obstacles, generally speaking. So I don't, and we've had now many cases that have been heard remotely that have not given rise to any issues. I mean, I think if you're writing a contract now and are aware of the possibility of remote hearings, you might want to cater for that in the arbitration agreement, just so that there isn't a dispute later on that somehow that violates the parties' due process or anything along those lines. But I can't imagine a Singapore court saying that in and of itself is something which is objectionable. So that's why I'm hesitating, because I don't see Singapore law or legislation or regulations being a hindrance to what parties desire, which is the efficient conduct of resolution of the disputes here.
I mean, we're from an institutional standpoint, we think that we're quite lucky in Singapore because we're one of the relatively rare jurisdictions where hearings have been proceeding during the course of the pandemic, physically, remotely, and then hybrid hearings as well, which may be the way of the future. But you're quite right in terms of virtual hearings, looking at the sets of institutional rules, because from an asset tracing standpoint, where are you going to be enforcing this eventually? And is there a requirement of an in-person hearing? I think that SIAC, that we are quite lucky in that the powers of the tribunal under the SIAC rules are quite broad, and the tribunals are able to conduct virtual hearings. Francis, of course, you've been practicing in arbitration in Singapore, arbitration and litigation for decades. Would you have any observations on the regime itself?
Yeah, I mean, as Paul and you've just emphasized, I think the regime is very flexible. It provides for a great degree of procedural flexibility, and the touchstone is simply, as between the parties and the arbitrator, what is appropriate, fair, and just. And so, you don't have a specific rule talking about remote hearings, but in the age of the pandemic, many tribunals and counsel and parties recognize that the only way forward in an appropriate, fair, and just manner is to hold remote hearings. And that's, as you rightly pointed out, that has been de rigueur in the last 1.5 years or so.
Paul, going back to you and let's say following from cases like Lufthansa, I was just interested for your clients, and because we have like a very strong litigation, mediation, arbitration regime, particularly with mediation, are you seeing parties wanting more preconditions, those specific 30-day periods prior to going to arbitration?
I certainly see that a lot. Whether that is necessarily thought through, I don't know. but it does seem to be pretty standard now that you would have at least some negotiation before the arbitration kicks off. And then there are varying degrees of how strongly worded they are. But I think that the sort of top tip, as it were, is to make sure that it's as specific and as mandatory as possible in terms of the language, if you're going to be insisting, or if one side is going to be insisting that those negotiations be followed through before arbitration kicks off. Because the law on this is 99% settled, I would say, but it's not. We've not had a case since Lufthansa, basically, to test various permutations of those clauses. And the advice of the courts there is that it needs to be specific and certain. As to what that is on the facts of each case will differ. So I think when drafting those, if the intention really is to force parties into a period of negotiation prior to arbitration, then I think they need to be very, very clearly, have that clearly expressed. Sometimes it's not.
I mean, it makes it more interesting for the institution because it may give rise to a prima facie jurisdictional objection. I'm sure that Aliona cannot count the number of cases that she's had where one side has said that they've complied with the preconditions or they don't need to comply, and the other side says they need to, and then you have the SIAC court deciding on this prima facie jurisdictional objection. We are very pleased that we're getting a lot of questions, and I think one of them is relevant. And Dimitri, if I could call on you, there's a question on how the Russian courts have treated Singapore-seated arbitral awards, so awards made in Singapore, including emergency arbitrator awards. Dimitri, could you possibly give us some advice on that?
Yeah, Thanks, Kevin. You know, Russia is a party to New York Convention, and by this token, all international arbitral awards shall be recognized and enforced in Russia by through this instrument. The question really is more practical, whether SIAC awards were indeed enforced in Russia, and I don't recall any successful enforcement. I think due to the fact that there are no many attempts to do so. However, I do recall one attempt when one SIAC award was tried to enforce in one of the regional Russian state courts. However, it was against the company which was based in Cyprus, and the court rejected this application on the basis that this company had no assets in Russia, had no proven assets in Russia, and the ruling was negative. You know, but again, the general principle that, you know, should be enforced. If there is an asset here, so this should be enforced. I also recall one interesting case, which quite infamously known in Russia, where there was an attempt to enforce the award of so-called Russian Singaporean arbitration. So it was in the early years of arbitration reform, and with you know, allegedly seat in Singapore. The Russian court made a conclusion that the enforcement of this award was an attempt to overcome the requirements of the Russian law for registering the permanent arbitration institution, and this institution is in fact kind of ad hoc institution, and never was tried even to be registered, and again rejected. Also, it came to the conclusion that all actions were happening in Moscow, not in Singapore, and there was no any real connection to Singapore. As for emergency arbitrator decision, I doubt it would be enforced in Russia, although it was never tested. Mostly because, you know, again, as a New York, based on the New York Convention, should be the final award, and partial or allegedly partial award would be difficult to enforce in Russia.
It was actually a very big day for emergency arbitration globally, because the Indian Supreme Court has come down in the Amazon Future case. And I mean, that's part of the challenges with emergency arbitrator awards. The advantage in Singapore, of course, is, as Paul said, is that orders and awards of emergency arbitrators are enforceable as though they are an order of the High Court for both Singapore-seated arbitrations and foreign-seated arbitrations. And I'm reminded of many of the awards that Aliona and I have worked on over the years that we presumed were going to Russia. And that's one of the advantages of SIAC, is that you have this scrutiny process, and we have experience of reviewing awards that could be going for enforcement in any jurisdiction. And I guess that scrutiny feature, Francis, would be a good prelude to your section. We have seen you in a great number of SIAC arbitrations, both as counsel and arbitrator, and of course you also run arbitrations under the auspices of other sets of institutional rules. What does an SIAC arbitration look like? Is it much the same as other institutions? Convergence, divergence? What is an SIAC arbitration like in your view?
Well, you know, Kevin, I think if you talk about the top arbitral institutions in the world, the arbitrations that you run before an SIAC forum is not very different. So I think the key feature that, you know, I do want to emphasize is that, as we all know, SIAC has been voted as the most preferred arbitral institution in Asia, and coming in only behind the ICC in the world, right? And so it is one of the lead arbitral institutions. And I would say that, you know, it comes as no surprise to many users, global users across the world. And that's why, it has an exploding caseload. And I just want to touch very briefly. The first thing is that, like other leading arbitral institutions, SIAC arbitrations are exemplified by a great degree of party choice and flexibility. We've spoken about just a while ago about the choice in procedure, appropriate procedure. And this includes, civil and common law tools of determining disputes, right? That's number one. Number two, parties have a great degree of flexibility in choice of counsel. Foreign counsel, local counsel, there is no bar. You could even employ a combination of the two. And in terms of arbitrators, you have a very wide choice. You're not limited to the SIAC panel, when you appoint, say, party appointed or even the president of the tribunal. But even just looking at the SIAC panel, there are more than 500 very experienced arbitrators from over 40 jurisdictions. The point is you have both common law and very experienced civil law arbitrators in that pool. I think, the thing that is on the minds of many arbitration users across the globe is the oft-repeated mantra of time and cost spent, right? Amount of time it takes and the cost spent. And there have been a lot of criticism of arbitrations. And I think this is where SIAC has actually created a brand name for itself. In recent comparative analysis by jurists of the leading arbitral institutions in the world, in terms of costs, SIAC was recognized as the most competitive option for both sole and 3 arbitrator member panels. That is significant. And in particular, as an example, for 3-member cases, the SIAC was found to be significantly cheaper than, say, LCIA or SCC, Stockholm Chamber of Commerce arbitrations. So that's significant. The next point, the same comparative analysts also carried out in terms of time. How long does it take? And again, the SIAC came out right on top. It was the most efficient arbitral institution. The median duration of an arbitration was 11.7 months, ahead of other leading arbitral institutions in the world. So I think those 2 factors are really on the mind of arbitral users. The last thing I want to touch on is the point that I think Paul and covered, and you spoke about, briefly, Kevin, which is the advanced and innovative rules that embodies the platform on which an SIAC arbitration is run. Emergency arbitration has been touched on, but there are a number of key ones. There are rules that relate to consolidation of different arbitrations, where the different disputes arise out of the same transaction or series of transactions, or arise out of the same legal relationship. So that's important. Joinder of a non-party to an arbitration is also possible with the consent of the relevant parties. Early dismissal of claims and defenses. Now, in a court action, you have summary judgment proceedings, right? To cut short, the dispute resolution process, if a claim or defense is obviously, largely unarguable. So the SIAC was the very first arbitral institution in the world to introduce a mechanism for early dismissal of claims or defenses that are either manifestly without legal merit, or say manifestly outside the ambit of the tribunal's jurisdiction. The last point I want to make in terms of the rules is, of course, and this has been referred to many times by jurists, the expedited arbitration rules. So under the expedited rules, you can actually have an award issued within 6 months. It will be in summary form, but you will have an award within 6 months of the commencement of the arbitration. Now, this is significant for cases where, of course, parties agree the claim is less than Singapore's 6 million, but also in cases where parties can't agree, but it involves a situation of exceptional urgency. I've seen myself being involved in a couple of them, how useful this mechanism has been. So for all those reasons, I think, and others which Paul touched earlier, SIAC has proven itself to be modern, innovative, and user-friendly. And I think that is reflected in the votes of the users, and it's in the way that its caseload is growing. Back to you.
Yeah. I mean, I often look at SIAC in Singapore as it's just easy and it just works. And the best marketing that we can do is when parties have an SIAC arbitration. I think that the availability of elite local firms and international firms in Singapore is critical. So for a Russian party can represent, or a Russian law firm can represent a Russian party. There could be a co-counsel relationship. You can instruct a law firm in Singapore. Arbitrators are fly in and fly out. Everything is designed to be very easy and resolve these disputes. Now, Nick, I feel constrained to call upon you for either Singapore or the SIAC rules. Obviously, we've seen you on cases under the SIAC rules, UNCITRAL rules as arbitrator and counsel. What is your view of the regime and running a case under the SIAC rules?
Thanks, Kevin. As I was listening to both Paul and Francis, the single thing that struck me most was what you have in Singapore is the coming together of Paul's observations about the context in which SIAC operates with Francis's observations about SIAC itself. And that may or may not be unique in the world, but it's pretty unusual, by which I mean the coming together of really a whole of government focus on making it easy and efficient to resolve international disputes with an institution that sits in that context, is committed to innovative rules, is committed to reform, is committed to doing a good job. That coming together of those two things, I think, makes for a special combination of factors for easy, not always perfect, but easy, efficient resolution of disputes. And I think outside of Singapore, it is difficult to quite understand just how central dispute resolution and SIAC is to part of the government's agenda. And I think you see the sorts of reforms and sorts of efficiencies that Francis and Paul rightly have described because of the centrality of the subjects we're discussing today to government efforts and just how effective those have been. So I think it's the coming together of those things, the context as well as the institution.
Nick, just while we have you here, and I think that we're very lucky with every panelist that has a balance of commercial work and investment arbitration work. How about the SIAC investment arbitration rules? We have this ongoing dialogue about incremental change or systemic change. Where do you see the SIAC investment arbitration rules? I mean, to be fair, VIAC has now released a customized set of this. Is this something that we're going to be seeing and parties will take advantage of going forward?
I think the answer has to be yes. The big question, Kevin, is what the time horizon is, and I don't know. We will see the speed with which the SIAC investment rules, you will correct me, introduced in 2017, right? Yeah. Become used more and more in investment treaties and investment contracts. But I think they will be. As SIAC's own prominence grows, so too I think will the prominence of the investment rules. I think it's worth noting the gateway question on SIAC's investment arbitration rules. Well, that is to say, there isn't a gateway question. One doesn't need to establish that one has an investment or that one is an investor. The rules can be applied because the parties agree to apply them. And so I think one of the things we tell our clients in the context of deal making is it's worth thinking about them in an investment contract context, you know, a PSC, a concession with a state or state entity, not exclusively in the investment treaty context, but also in that investment contract context. And I wouldn't be surprised if the early phase of use of those rules to resolve disputes is in investment contracts with states and state entities rather than investment treaties, though clearly they are available for both.
Mm. And I suppose there's a threshold question in a treaty of or whether you want to be under the Washington Convention or the New York Convention. We're actually seeing, Francis was talking about how the SIAC rules are quite customizable. We're actually seeing parties that are importing features from the SIAC investment arbitration rules into the commercial rules. So the parties will agree that we want the list procedure from the SIAC investment arbitration rules in the commercial rules. So they really are flexible, and you could have the SIAC investment arbitration rules in a purely commercial dispute. Julia, I just wanted to call on you because of course you're an ICC court member, an LCIA court member, and you've got all of these different sets of institutional rules. And I'll ask you a direct question on consolidation. So when you're running those multi-billion-dollar major project disputes, are parties looking at whether or not you can have different parties in a consolidation application? So the institutional rules are different on this, but the fact that the SIAC rules do not require identity of the parties, is that relevant? And how much are parties looking at the different institutional rules anyways, or is it just a question of landing at that agreeable second choice that's comfortable for both parties?
I think the times of just landing with a first or second choice are long gone, and I think the parties are now shopping for different institutions and for different rules. And certainly for consolidation, we are seeing more and more requests from clients when they are beginning to think about the need for consolidation as transactions become more complex, involving more parties, cross-border transactions where you have often a large deal which starts by having 3, 4, 5, 6 different institutions being imported from different boilerplate transactions, boilerplate rules. We see parties asking questions about consolidation. And I would say that the ability to join third parties, the ability to bring parties that ordinarily you would not expect to see in an arbitration is becoming more important. And those institutions that will think, or at least make a conscious choice about on that subject will be the winners.
It almost harkens back to the cross-institution consolidation protocol, because these in suites of contract, particularly when parties are using boilerplates, you will end up with maybe 100 contracts that might provide for 3 or 4 different institutions. And how about, of course, because you have a lot of Russian work, how about the choice between London and Singapore? So with you on the ground, are you seeing that shift of Russian parties that are looking more to Singapore?
Well, you will have seen the Queen Mary report, the recent one, and certainly it has surprised many that Singapore has really shot up and is sharing a proud place there at the top. And I think Singapore has become more prominent in recent years. Clients are asking about alternative seats. And in the last year and a half, with the emergence of online hearings, when parties are beginning to realize what we've been telling them all along, that a seat of arbitration is not necessarily where you need to fly for many, many hours, they are beginning to make a conscious choice of the seat. And as I also will talk later, sanctions will play a part. People will start moving away from those traditional imported from boilerplate clauses, seats that we have seen in the preceding decades. So yes, I have seen Singapore's seat, whether or not together with SIAC or whether with a different institution, we are seeing far more Singapore seats in our clauses than we have ever done before.
Oh, that's great to hear, and it can work in both directions. You could have a Singapore seat with any of the other administering institutions, or you could have an SIAC arbitration, for instance, with a London seat. Because Aliona does so much of our Russian work at SIAC, Aliona, if I could pass to you to discuss the Russian dispute resolution regime with Dmitry. There is a lot of economic activity in this Russia-Singapore corridor, so we're pretty excited about the future potential there, and good for our Singapore users to know what it's like doing business in Russia.
Yes, absolutely. So thank you, Kevin. Of course, looking into the Russia international arbitration regime, it's not an easy task, as we all know it's quite a complex structure and there are quite a lot of aspects to look into. And as mentioned, if I maybe can ask our Russian panelists, starting with Dmitry, to let us have like an overview of the Russian arbitration regime. Mostly, what are the institutional preferences of Russian parties? Is it when we're talking domestic versus international arbitrations, what kind of seats are preferred? What kind of laws the Russian parties choose? So if maybe I could ask Dmitry to kickstart the discussion, and then we'll tap into that.
Thank you, Aliona. Yeah, indeed, it might seem quite complex, and I don't think I can cover everything, but I try to give the basic overview. I slightly change the order of your questions and probably start with preference of the Russian parties in respect of the choice of the arbitration institution, and then go to choice of seat and applicable law, and then I would like also to outline the features of obtaining interim relief from Russian courts in support of arbitration, which I think it would be interesting to know, and to finish with some general tips. So again, different kind of disputes I usually refer to domestic or international commercial arbitration. And Russian law on commercial arbitration provides that the following disputes can be settled in international commercial arbitration. Disputes first arising out of private relations in the course of conduct of overseas trade and other types of international economic relations. When, second, the commercial enterprise of at least one of the parties is located abroad. And third, a place of execution of most part of the obligation or the place with which the subject matter of the dispute is most closely connected is located abroad. So generally, the idea is behind disputes being recognized international commercial arbitration is that it should be a significant foreign element in the transaction, in the contract, and then you can refer to international arbitration. The law on commercial arbitration separately lists investment disputes as the type of dispute capable of being settled by international commercial arbitration. So all other disputes, although arbitrable and not meeting the criteria I mentioned, are considered to be domestic. So also, ad hoc arbitration is allowed in Russia for the majority of arbitral disputes. However, Russian parties elect institutional arbitration much more often, and frankly speaking, the government and legislation favors institutional arbitration rather than ad hoc arbitration. So in order to administer arbitrations in Russia, the institutions must obtain a license from the Ministry of Justice, which grants them the status of permanent arbitration institution. I don't want to go deeply in details because it's going to be in next session. However, I just mentioned that foreign permanent arbitration institutions, although licensed by the Ministry of Justice, do not administer domestic disputes unless they have they have opened an office in Russia and deposited the rules. So far, none of the foreign permanent arbitration institutions recognized by the Ministry of Justice did so. So it's also common practice to include an arbitration clause with the choice of Russian institution in the situation where any disputes are expected to be small scale. So, and this is this can be explained by several factors. First, the cost of arbitral proceedings before the Russian institution is quite modest comparing to international institutions. So, second, Russian institutions are considered to understand local specifics in Russia better than international ones. Third, in enforcement proceedings, the Russian courts are expected to scrutinize the awards which originated from local permanent arbitration institutions less severely, although it's not rule always, but this expected by the users. And finally, there are 6 currently Russian permanent arbitration institutions licensed by the state, by the Ministry of Justice, which are developing themselves to provide better level of service. And there is quite a progress recently in doing that. For example, many institutions introduced the possibility to conduct virtual hearings, which never happened before. So this is, again, still a long way to go, but the level of services is becoming better. So foreign arbitral institutions, in particular in the Russian context, such prominent Western centers as ICC, LCA, and others, have been institution of choice for large-scale international commercial disputes. So this is also very often becoming from the tradition. For example, SCC and SIAC have been popular centers with Soviet users since the Cold War. And when many Soviet commercial enterprises included this SCC and SIAC arbitration clauses in the contracts, and very often in the typical forms of contracts, which both Stockholm and Vienna considered to be neutral locations for locations for the parties which belonged to Warsaw Treaty Organization countries or the NATO countries. So then, after Soviet Union collapsed, ICC came to the scene, mostly with focusing on construction, infrastructure disputes, and then LCIA also became very, very popular, mostly because of the dominance of English and American law firms in the Russian legal markets, which brought this tradition and included the arbitration clauses, LCIA arbitration clause in financial and M&A transactions. However, again, recently Asian arbitration institutions, in particular SIAC and Hong Kong International Arbitration Center, became increasingly more popular among Russian users. And there are several factors. First, many businesses are concerned about the effect of sanctions on potential arbitration proceedings in Europe. In fact, many arbitration users reported the severe difficulties of paying arbitral costs and registration fees to major arbitration institutions. I don't, again, want to go deeply in details because it's going to be separate session. However, I just mentioned that in my experience, for the same sanctioned clients in 3 different ongoing arbitrations, 2 in 2 major European institutions, ICC and SCC, it took a very long time to overcome difficulties of paying registration fees and arbitration fees, while in SIAC it took several days to do the same. So, which is clearly the advantage of SIAC over other institutions. Although, to be completely transparent, ICC is trying to settle this by obtaining several licenses. SCC is also doing big progress. SIAC allegedly resolved this issue. So, and the second issue, it might be a bit strange. It's probably not an issue, but concern. Although maybe unjustified, but quite understandable, that many Russian users are concerned about neutrality of the European arbitration institutions toward Russian users. It's probably a perception. It's not proven somewhere, but the perception is quite strong. And the third factor, both SIAC and Hong Kong have been granted license as a PIA by the Russian Ministry of Justice. And all these factors definitely encourage users to go eastward. So next subtopic, preference on seat of arbitration. Again, Russian law mandates the Russian seat in certain cases. This is the case for all domestic disputes out of concession agreements, and certain corporate disputes. For example, when disputes arise out of the articles of association of a company. After the introduction of the new Russian federal law on arbitration, the Waterfall or alternative clauses, or sometimes referred as Cascade clauses, have been increasingly popular. Why is it so? In the beginning of the reform, and even before the reform, many users started to put the Cascade Waterfall clause into the contract in the fear that some traditional institutions will not obtain the license from the Ministry of Justice, and then some of the awards or some part of the awards or some part of the contract might be enforceable, might be not enforceable in Russia. So that created some confusion. However, again, with the fact that four leading worldwide international arbitration institutions, ICC, SIAC, and Hong Kong Arbitration Center obtained the license in Russia. This Cascade Waterfall clause became less popular and less envisioned in the contracts. So again, and finally, the observation is that it is worth noting that choice of foreign seat does not necessarily prevent from holding of the hearing in the territory of Russia. So that's also possible. So preference on applicable law. It's quite a big topic. However, I just say a couple of words that among Russian users, English law still remains very popular, in particular in M&A and financial transactions. And there's, I think, it's a bit of inertia, and also the transactions which concluded earlier still have this choice of applicable law. Russian law also has been has become more popular, including in small and medium transactions and M&A transactions, sometimes in the big transactions. Again, due to the recent reform of corporate legislation and arbitration reform. Again, for instance, Russian law now provides for shareholder agreements, although previously they were considered in contradict of the Russian public policy. So besides, Russian law is mandatory for certain types of transactions, for instance, real estate transactions and others. So it also worth to note that in complex deals, there might be they may be broken down to a combination of transactions governed by simultaneously by Russian and foreign laws. For example, it is quite common to see the facility agreement governed by English law and share pledge agreement securing performance of obligations governed by Russian law. So this creates some competition of institutions might create some, because, for example, pledge of shares of real estate should have exclusive jurisdiction of the Russian courts. So and then it might create the competition of forums. In practice, if one of the counterparties has a strong negotiation position, the chosen law is often the law of the country of origin in international trade. Sometimes the parties, very often, not sometimes, parties choose the substantive law of the place of arbitration. Very often Swedish law in cases with SCC as an institution. Very often in oil and gas transaction and in construction transactions. So furthermore, the parties can choose non-national systems of law. For instance, the UNIDROIT principle on European contract law, and etc. So this is allowed in arbitration and accepted by some state courts, and including Russian courts, but frankly speaking, rarely used. And finally, systems of national law often incorporate international treaties, such as Vienna Convention of Contracts of International Sales of Goods and others. A couple of words of interim relief. Russian law indeed empowers the courts to grant relief in support of both domestic and international arbitration. But generally, Russian courts are very reluctant to grant interim relief. So that should be known. It's quite probably unusual for English practitioners, probably for Singapore practitioners, but it's the statistics says that it's probably 10% of chance to obtain the interim relief. So normally interim relief is a freezing of assets. However, no exhaustive list of measures exists. Various restricting injunctions are also practiced, We also encountered injunctions that impose an obligation to make certain actions rather than restrain from them. So we see more requests to obtain reliefs in support of international arbitration, and that's becoming more open and more used. And finally, I would like just to give a couple of tips for parties doing business in Southeast Asia from my experience. Again, first, there is no doubt that dispute resolution clause in context should refer to arbitration. It's very unfortunate that party would insist on the local court. Second, almost every country has its own arbitration institution. Again, in Russia, there are 6 of them. I guess there are a lot of in Southeast Asia, and the preference would be to choose the world-renowned institution as a neutral with better services. Third, if an award is likely to be enforced in Russia, I think the parties should pay attention to special requirements of Russian law governing arbitration, including the issue of arbitrability and special requirements for arbitration institutions which handle certain types of claims, I mean corporate disputes. So if the seat is in the Southeast Asian country, I would recommend to use local counsel, to engage local counsel, and I have now, as Kevin mentioned, the advantage of co-counseling on one big case in this region with local firm. And finally, just a common tip: take account of cultural differences. If you do that and engage as a partner of local counsel, you would benefit from this quite widely. So with that, I would finish. If any questions, I'm ready to answer.
Well, thank you very much, Dmitry, for such a comprehensive overview of complex Russian arbitration microcosm. I'd like to ask you more questions, but because we're a little bit constrained on time and we need to cover 2 more extremely important aspects, so the permanent arbitral institutions, the registration in Russia as such, as well as the sanctions, I would ask Nick maybe to move our discussion along and let us know the background generally of the permanent arbitral institutions, what it is, what kind of practical implications it has if, let's say, SIC has become a permanent arbitral institution, and specifically if maybe you could give us some other insights whether that affects certain types of disputes differently. So Nick, over to you.
Thanks, Aliona, and hello again, everybody. I'm very happy to offer a brief overview of the consequence of being a permanent arbitral institution. I say hastily as I launch into doing that I speak under the control of Dmitry and others on this panel. I am not a Russian lawyer. I think the limit of my qualification to speak to this topic is that together with my Moscow colleagues, I represented SIAC in its PAI application, which together with the ICC was granted in May of this year. And as Dmitry rightly said, there are 4 international arbitral institutions that now are registered as permanent arbitral institutions in Russia. In addition to SIAC, they are, as I said, the ICC, granted at the same time as SIAC, and also, as Dmitry said, the Vienna Center and the Hong Kong Center. Let me start with what it is not. Being a PAI is not a general requirement for an award to be enforced in Russia. As others have said, Russia is a party to the New York Convention and in principle recognizes foreign awards and enforces foreign awards. So it's not a general limit on enforceability of foreign awards. So what is it? The context is this: the Russian law limits the arbitral institutions that can arbitrate certain types of disputes involving Russian companies. And that category of disputes in Russian law is, as Dmitry has said, so-called corporate disputes. And others can add more color to what constitutes a corporate dispute, but let me try to simplify it. It will involve most post-M&A disputes where in issue are shares in Russian companies. So disputes about share transfers, disputes about option and pledge agreements, for example, will, as I understand it, as a matter of Russian law, constitute corporate disputes. Again, the consequence of being a corporate dispute is to be arbitrable. That dispute must be determined by a permanent arbitral institution, PAI, registered in Russia. No other institution can determine such disputes. There are the four international institutions I've already introduced, including, of course, among them SIAC, and there are also local Russian institutions that can determine such disputes, the most obvious one being the International Commercial Arbitration Court, ICAC. Before I move on, let me say there is a footnote that I should offer at this stage, which is some corporate disputes may nonetheless be non-arbitrable altogether, and the need for Russian advice on that is obvious at the point of transacting. And I'm thinking in particular of contractual relations involving so-called strategic entities, and where a Russian company is classified as such, as I understand it, it is not possible to arbitrate disputes with that strategic entity. So need for caution at the outset. Let me make just two final observations then in the context of permanent arbitration institutions like SIAC registered in Russia. One is this, and that is a debate about whether those institutions are required to promulgate specific corporate arbitration rules in order to be able to resolve the sorts of disputes I've introduced. And as I understand it in Russian law, there is a debate about that, and there is an arguable conflict between two pieces of legislation, the more generous view being that any such requirement appears to no longer exist, such that SIAC and the other PAIs abroad outside of Russia can resolve corporate disputes, notwithstanding the fact that they do not have standalone, discrete, specific corporate arbitration rules. Final point then is to come back to very briefly to Dimitri's observations about Cascade or Waterfall clauses. Those have been very widely used at least until recently in Russia-related transaction documents. In short, dispute resolution clauses that provide a descending order of priority for arbitration institutions as agreed between the parties on the basis that the first in that list that is a PAI at the time a dispute arises will be the one to resolve the dispute, and one goes down the list until one hits a registered PAI. Of course, now that there are four, including SIAC, perhaps the use of waterfall clauses, cascade clauses of that sort will be less important because there are at least four good choices, including SIAC, without the need for a waterfall clause. I'm going to pause there, Aliona. Thank you.
So, well, thank you very much for such a clear explanation of what we are talking about. Before we move to our last segment on sanctions, which Yulia will be talking us through, can I ask our Russian colleagues whether they have anything to add to the discussion of the permanent arbitral institutions, and any insights on the legal risks or considerations? Dmitry, Yulia, none? Okay, then I think let's move on to into the sanctions topic, which is an extremely complex one as well. And if I could ask Yulia to let us understand what are we talking about and let us know the specific legislative provisions which are in play here.
Thank you very much, Aliona. Well, as we know, the indirect effect of international sanctions can have a significant impact on international dispute resolution. And from concerns over delays and accepting a dispute involving a sanctioned person by an institution, finding a tribunal actually willing to be appointed and being able to pay arbitration fees, to enforcement of awards, all these factors force users to look for alternative solutions in their dispute resolution arrangements. Whilst arbitral institutions based in the EU states are subject to EU law and are therefore required to observe EU sanctions regulations, these sanctions actually do not result in a substantial change in the administration of arbitral proceedings. And back in 2015, we will all remember that the ICC, the LCIA, and the SCC issued a note on the potential impact of the EU sanctions against Russian parties in international arbitration administered by EU-based institutions, explaining this because everybody was concerned that Russian parties will drop the EU institutions and run away looking for alternatives. And since then, each arbitral institution has put in place a system to ensure that their internal mechanisms are sanction compliant and are acceptable to the regulatory authorities and also to the banks, enabling them to handle deposit monies. However, as Dimitri, for example, mentioned, there are still problems, and certain restrictions such as asset freezing restrictions do require additional administration on the part of everyone involved in the institutional arbitration proceedings. And this in itself has caused delays and uncertainties also over the length of time it might take to resolve such administrative issues, even if the majority are resolvable. And consequently, parties involved in a dispute affected by an international sanction can face literally months of delays in getting it resolved. And obviously delays can go on for longer if the impact of the international sanction also changes over time. And this is a real issue. And against this background, of course, the fact that Singapore did not introduce Russia sanctions therefore gained heightened importance in the eyes of many Russian businesses. The fact that generally SIAC does not need EU or US sanction licenses to administer disputes involving sanctioned entities has been cited by many as placing this institution above those based in the EU or UK. Although this does not insulate SIAC arbitration from the effect of Russian sanctions entirely, there remains a strong perception that they are less exposed to the risks associated with the sanctions than most Western institutions. This also reduces the risk associated with Russia's 2020 anti-sanction legislation, which allows Russian parties to litigate their disputes in Russian courts, where foreign arbitration is hampered by sanctions, which I will address in a couple of moments. I'm also not going to dwell on anecdotal evidence that Russian parties consider that arbitrators who are citizens of countries that have imposed sanctions may be less impartial than those from countries which do not impose sanctions, such as Singapore. However, one must also remember that arbitrators from countries where breaking international sanctions carries a criminal liability are likely to decline to act in certain disputes. So moving on to Russia's anti-sanction legislation, it's called the Russia's Foreign Sanctions Law. It came into effect just over a year ago in June 2020. And pursuant to this law, Russian courts have exclusive jurisdictions over disputes involving sanctioned persons, as well as over disputes arising from Russian sanctions. Russian courts may establish such exclusive jurisdiction where A, there is no arbitration or choice of court agreement, or there is a valid agreement to arbitrate or litigate outside Russia, but it becomes unenforceable as a result of sanctions, therefore creating what is called obstacle for access to justice. And when these circumstances exist, a sanctioned party is entitled to apply to a Russian commercial court, either to have its claim resolved on the merits, provided that an identical dispute is not already pending before a foreign court or a foreign tribunal, or to obtain an anti-suit or anti-arbitration injunction prohibiting foreign proceedings. And from a practical perspective, the provision concerning the so-called obstacles, which may render unenforceable an otherwise valid arbitration agreement, is the most ambiguous provision. In this regard, the law delegates to the courts a rather wide margin of discretion. Its practical impact is therefore largely determined by the Russian court's interpretation of what it is meant by obstacles for access to justice, and what is meant by the unenforceability of dispute resolution clauses. And on their face, the provisions of this law appear broad. However, in its recent ruling, in the Uralstran smash case, the Russian Supreme Court followed the welcome restrictive interpretation of this provision. And the court refused to grant Russian rail maker Uraltransmash, UTM, an anti-arbitration injunction to halt the SCC arbitration brought by Polish company PESA. The dispute concerned a contract for the purchase of rail cars, which was concluded back in 2013. And in 2014, UTM's parent company became subject to EU and US sanction regimes. In 2019, the Polish company commenced arbitration against the Russian company seeking damages. The Russian company initially participated in the arbitration. However, after the foreign sanctions law came into effect, it applied to the Russian court for an anti-arbitration injunction. Russian courts concluded that the fact that the Russian company was subject to sanctions was in itself insufficient to grant the injunction. They noted that the Russian company had actively, in fact, participated in the SCC arbitration for over 2 years. In particular, it appointed a well-known and respected arbitrator. It appointed a Polish accounting expert witness. It filed a number of submissions, including a counterclaim, and it was advised by well-regarded Russian and Polish lawyers. And the fact that the company was represented by prominent Russian and Polish lawyers and expert witnesses undermined its claims to have faced difficulties in transferring funds to foreign representatives or to the SCC in the European Union. And therefore, the courts concluded that there were no obstacles impeding the Russian company's right to a fair hearing. So obviously, UTM's case is fact-specific, and there is a risk that if, for example, a sanctioned party is unable to commence or pursue proceedings, a Russian court may establish their exclusive jurisdiction. And there was a Telegraph case that I was going to briefly mention where the court rejected the defendant's objection against the Russian court's jurisdiction, disregarded the jurisdiction clause and considered the case on the merits. But there, the Russian party was able to prove that it was unable to retain suitable lawyers and receive qualified assistance in the UK and in the US. So to conclude, and going back to the sanction regime in Singapore, as a member of the United Nations, obviously Singapore implements the resolutions passed by the United Nations Security Council through its domestic laws, and these include various embargoes and sanctions. The countries currently affected by the regulations for targeted financial sanctions are Iran, Libya, Congo, North Korea, Somalia, Sudan, and Yemen, and Singapore does not enforce unilateral sanctions imposed by other countries. So has SIAC seen an increase in caseload that might give an indication that it will be rewarded for Singapore's stance on sanctions? We've already heard today that SIAC had over 1,000 new case filings, and the highest since SIAC commenced operations in 1991. What about the Russian parties? SIAC statistics show that, and Alona will correct me if I'm behind on this, that in the past 10 years, it had 13 cases involving Russian parties. Last year, it had 3 new cases, and in the preceding years, since 2018, the rest. But if we look at the latest Quinn Mary survey that I already mentioned, there's been an interesting movement within the top 5 rankings. And whilst London remained at the top of the charts, for the first time, it shared this position with Singapore. As practitioners, we see and draft more and more arbitration clauses where the parties agree to refer to disputes to SIAC. And in my view, the perceived image of Singapore as a sanction-free zone plays a significant part in the choices made by parties. In my view, that role is more important than its registration as a permanent arbitral institution in Russia, but we shall see. And it's certainly the user's market now, with users having the opportunity to pick and choose the most suitable, the most flexible, and the most convenient institution and jurisdiction for its needs. SIAC has certainly gone to the top in its efforts to respond to users' concerns, and I'm confident that we will continue seeing a rise both in Singapore being chosen as the seat and SIAC being chosen as the institution for many with those concerns. Thank you.
Thank you, Julia. A follow-up, because I think it's important, and this is something that all institutions are dealing with. Obviously, as SIAC, not only do we have Aliona to administer these disputes, but we have compliance procedures in place in order to assist with the movement of money And for our part, our cases involving Russian parties have functioned almost exactly the same, no unbargained for delays. But I was wondering if you could give us some advice on the potential impact of secondary sanctions. So Singapore doesn't enforce unilateral sanctions, but what about in terms of choice of legal counsel, experts, governing law, arbitrators? Any advice that you can give to parties or to the attendees on this?
I think most users are primarily concerned about having access to information about how long things take. From the point of an institution, if an institution explains how, for example, I don't know what's the banking arrangements with SIAC, but I presume that the banking arrangements are such that the sanctions do not bite. Yeah. But many Russian users will want to know that upfront and be assured that that's the case. As for the choice of arbitrators, I think the users are realizing that they need to be making greater research about where the arbitrators come from, what their nationality is, and whether they have any restrictions, because a lot of time can be spent on going through, the first choice candidates, second choice candidates, and so forth. So any guidance that an institution can give on that research would be much welcome. And as for counsel, I mean, we as me being a lawyer working for a large international law firm with a significant American and EU presence, we always have that choice. We make a choice whether to obtain a license or not to obtain a license. So I think there are plenty of lawyers to choose from, plenty of counsel to choose from. And I second what Dimitri was saying. It's always important to work with local counsel, with counsel that knows the region, even if you think that the knowledge in general on the applicable law might be the same. It's sometimes it's the procedure that matters. And as for the applicable law, well, for Russian parties at least, I agree with Dimitri that Russian law English law will remain at the forefront of the choice. But again, in terms of sanctions, that probably has less of a significance than anything else. But looking from the sanctions point of view, if I were to take anything away from dealing with different institutions, is transparency and the institution's ability to say before, even at the point of before the dispute arises, to remind the parties that they should call an institution and actually walk through all the steps that require to be taken that might be affected by sanctions. And I think that's the best advice I can give.
As an institutional representative, I completely agree with that advice. What we've found, and just further to your point, because there is not a US correspondent bank in between the making of deposits or paying of arbitrators, we haven't had any difficulty with the movement of money, but we also try to be commercial about it in terms of a qualified third-party remitter or the tranching and the stages of the deposit. So I guess what I would say to all of our Russian attendees is that Russian parties at SIAC, these function very normally. We haven't had any issues and our timelines have been good. I'm looking at the time, and I could certainly continue this discussion for a lot longer, but we are so appreciative to all of our panelists today for joining us. This is a very important and valuable discussion, and it is a further indication of our long-term commitment to Russian users and of course users around the world. So thank you very much to our panelists. Thank you to our attendees. And we wish everyone from me and Aliona in Singapore, a very good evening. Thank you.